right. Anybody threaten you or coerce you in any way?
Kind of.
Okay, what do you mean, kinda?
I don't want to go to jail again, Your Honor.
Okay, but did somebody threaten you to plead?
Yeah, with jail time, Your Honor.
Okay, but who did that?
Well, technically, you, Your Honor.
Ashley Bashir on behalf of Mr. Hampton.
State your name.
Brandon Hampton.
Thank you.
Mr. Hampton has entered into an agreement with the people, and would like to enter that into the record.
The people of October
Thank you.
we did not write that to the agreement. He has been admitted to the 15th District Court Mental Health Court.
Got it.
Today, at his preliminary exam in 24 at 55262, he'll be entering a plea on Tuesday to attempt RNO, and that case will go to the 15th District Court Mental Health.
Got it.
Your Honor, is it possible to enter into both today, to address both cases today on the record?
That file is not in the courtroom.
Oh, okay, got it.
But I do believe that the building that you answered.
Oh, sorry.
But I don't believe it's.
What? Okay.
Talking about bond. That's
All right, we'll just address this case today.
He's going to enter a plea in another case
Uh,
that's set for prelim.
Yes, yeah. So case 24F55262, just because of the timing with the mental health treatment court evaluation, that one was set for preliminary examination before the evaluation was complete. And that is currently set for exam.
So over there is Ann, right?
Yes.
You know Ann?
Yes.
Okay. So if you had this, that may work out where we could like get rid of two cases and he could plead. I may or may not do it, but usually just go over and ask Ann. Because you asked me on the record, I'll probably say no, because I don't do the filing, so I don't know where it is.
Understood. Yes. So I will.
So would you like to do that today?
I would like to.
So here's what I'll do. I'll pass it. Go talk to Ann.
Thank you very much, Your Honor.
You're welcome.
Your Honor, sorry. Ashley Bashir on behalf of Mr. Hampton. And in addition to addressing the case directly, we would like to address bond and request that a condition, specifically the home confinement tether, be reconsidered.
Okay, I'll get to that maybe at some point.
Good, thank you. Yeah,
Right now, I'm trying to get these pleas done.
thank you.
So my understanding is he's going to plead to count in case ending in 1596. He's going to plead to count 2.
Yes,
Correct? With count 1 being dismissed. That's going to be a guilty plea. Correct, counsel?
Yes.
All right. Then on the other matter, I have a plea form that indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, count 1, the resisting and obstructing would be dismissed. And there is an agreement that the defendant is to go to mental health court. That's the court's full understanding of the agreement.
That's right.
May I have the defendant's one?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name.
Brandon Hampton.
Man, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor offenses. Is that correct?
Yes.
All right. The first one, in the case ending in 1596, is the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Mhm.
Yes?
Yeah.
Okay. You also understand in that case that while I'm taking your plea, I would not be your sentencing judge. and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yeah.
Okay. And understanding that on that case, do you still wish to plead guilty?
Yes.
All right. On the other case, it says court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Why are the judges different, Your Honor?
Why are the judges different? Because these allegedly occurred in two separate places. The case that we're just talking about with Judge Valvo, the offense took place in the city of Ann Arbor. And the other case happened in maybe the city of Ypsilanti or yes, in Ypsi City, it looks like. I'm sorry, Ann Arbor Township. Okay, so they occurred in two separate jurisdictions.
Okay.
Okay, that's why you have two separate judges. But what's going to happen, I think this is probably really the crux of your question. You're going to go to mental health court on these, right?
Yeah.
So Judge Valvo is actually in charge of mental health court. So when that case goes over to her, that will be where it is. You'll have to go before Judge Barr. Judge Barr will do the initial part of the sentencing and then place you on probation to be supervised by the mental health court. Follow that? So it's just a little bit of a process. Both cases, it's anticipated, are going to end up in the same spot.
Okay.
Okay. You got that? Any other questions on that?
I guess it's not like possible for the other case just to go to Valvo as well.
It will get there. It just can't go directly that way.
Okay.
Okay.
For sure.
Anything else? Trust me, we do this all the time. It'll get there. So it'll catch right up to it. Okay. All right. Any other questions you have?
Just the one about bond, but
Yeah, we'll get to that in a moment. All right. So understanding all of that, you still wish to plead guilty to these charges?
yeah,
Okay. So to the charge of aggravated assault, how do you plead?
guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yeah.
All right. You signed an advice of rights form, correct?
Yeah.
Do you have any questions regarding any of those rights?
No.
All right. You see a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yeah.
All right. Were you on probation at the time of these offenses?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No.
All right. Anybody threaten you or coerce you in any way?
Kind of.
Okay, what do you mean, kinda?
I don't want to go to jail again, Your Honor.
Okay, but did somebody threaten you to plead?
Yeah, with jail time, Your Honor.
Okay, but who did that?
Well, technically, you, Your Honor.
No.
Well, technically, you, Your Honor.
And so I stated the terms on the record. And Mr. Hampton, I'm going to ask you a couple questions again.
Okay.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No.
Has anybody threatened you or coerced you in any way to get you to plead?
No.
You're doing this voluntarily,
Yes.
of your own free will.
Yes.
And because you believe that you're guilty of these offenses?
Yes.
All right. We'll start with case 1596. Paperwork. So, okay, Mr. Hampton, on the date of August 29, 2024, at Washtenaw Community College in Ann Arbor Township, Washtenaw County, State of Michigan, do you recall what happened on that date regarding a Vladimir, is it Parahorov?
I don't know, Your Honor.
All right, did you get into a fight with somebody?
Oh, I know what happened. I don't know what his name is. It sounded like
Okay, why don't you tell me what happened then?
Oh, I was trying to take a shower, Your Honor.
Okay, and then what occurred?
When I was in the locker room, he had pushed me up against the wall, hit me in my head, and threw me on the ground. And then broke in my property.
Okay, but before that, did you do anything before that?
No,
Okay.
it wasn't until there were 4 people on top of me and I was fearing for my life that I bit him, Your Honor.
Okay, so here's what I'll do. It's not gonna work. So if you guys want to change, I'm not suggesting if you guys want to change things to a no contest. If you want to do whatever, what I will do is I'm back up at 1. I'll call it back up at 1. I think everybody's still going to be here. So, and give you a chance to talk with him, decide whether or not you want to do no contest, please explain what a no contest, go through all of that with him, and then see if we can get this done.
Thank you very, very much, Your Honor. Appreciate it. Thank you.
This is a prime example for me of no good deed goes unpunished. All right, so we'll call it back up at that point. Quarter past these matters again. All right.
We actually, based on the most recent conversation with my client, I will actually seek to adjourn this case for to further advise my client on the offer.
All right.
For the shortest adjournment possible.
February 13th. Both matters.
Thank you very much, Your Honor.
Both matters? I don't have to come on.
Well, that's true. What are we doing with, well, when is the exam set?
Tuesday.
Yes, so would it, apologies. We can see, I'd be happy if I'll stick to adjourn that, the exam or for the other case.
Well, you're gonna need a step on the exam.
Yes.
Observe the
After the
1596 on the exam.
Yes.
But I only took it because there was gonna be a plea. When do you want the other one adjourned to?
When is the soonest?
I'll set this, I'll adjourn the
After the
1596. I'll adjourn 1596 to February 6th. The other one is stay on track for a preliminary examination. I understand that people are not going to have the witnesses available, or you need a stipulation to adjourn that out.
Thank you.
Okay.
Thank you, Your Honor.
And
As we wrap up this intense courtroom exchange, let's take a moment to break down exactly what just unfolded, because this case was far more complicated than it first appeared. What looked like a simple plea hearing quickly spiraled into confusion, hesitation, and unexpected revelations from the defendant, Brandon Hampton. And if you've been watching closely, you probably felt the tension rise the moment the judge questioned whether Hampton had been threatened or coerced into entering a plea. This moment matters legally. It's huge. When a defendant says, even slightly, that they feel pressured, the entire plea can fall apart. A judge must confirm that every guilty plea is voluntary, intelligent, and fully understood. So when Hampton responded with kinda and referenced jail as a pressure point, the judge had no choice but to pause everything. That's not a small issue. That's a red flag that could make an entire plea invalid in the eyes of the court. Judges take plea integrity seriously, because a plea made under pressure can get overturned later, causing more legal chaos for everyone involved. This led to the judge temporarily stopping the hearing, urging both sides to step aside and talk things through privately. That break wasn't just procedural, it was absolutely necessary. Hampton was clearly confused about the judges, the jurisdictions, the mental health court process, and how all these cases would merge. His questions were valid, but they also showed how overwhelmed he was, and in a system this complex, confusion can easily turn into panic. Now let's talk about the mental health court element, a crucial piece of this story. Hampton's cases are expected to funnel into mental health court, where the focus shifts from punishment to treatment. That's why multiple judges are involved. Different jurisdictions, different original filings, but ultimately, all paths seem to lead toward a unified mental health court structure designed to supervise, treat, and stabilize individuals dealing with mental health challenges. This is a major opportunity for Hampton, but only if the process is completed correctly. Another major plot point happened when Hampton was asked to describe the incident in the aggravated assault case. He depicted himself as the victim first, claiming he was attacked in the locker room and only bit the other person when 4 individuals were on top of him and he feared for his life. This creates a narrative challenge. For a guilty plea to stand, the defendant must admit to the elements of the crime. If the defendant instead describes self-defense, the judge cannot accept the plea. It contradicts the legal definition of assault. The judge recognized this immediately, hinting that a no-contest plea might be appropriate. That alone shows how delicate plea-taking procedures truly are. Ultimately, the court decided to adjourn, allowing more time for counsel to explain the plea deal, the mental health court structure, and the consequences. This was the right call. A rushed plea today could become tomorrow's overturned case. The judge's caution here isn't just legal procedure, it's good stewardship of justice. As viewers, this case raises powerful questions. Was Hampton truly overwhelmed, or was he trying to avoid admitting guilt? Did his conflicting statements reveal fear, confusion, or strategy? And importantly, should courts do more to simplify processes for defendants dealing with mental health issues? One thing is clear. What happened here wasn't just a plea hearing. It was a real-time example of how fragile, human, and emotionally intense the justice system can be. A single word kinda nearly shifted the entire outcome, and now, as this case heads toward February for further review, one thing's for sure, the legal road ahead is far from over. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.